Okay, I thought I'd do a little history this afternoon. And this talk is based on a chapter of a book I'm working on called Sexing the Constitution, which is about the history of sex law, religion, and ultimately constitutional law. And I'm going to use a text because a lot of it, because it is history, it's important to get the specifics of it right. So at the time the Constitution was enacted, there were no laws in the United States prohibiting or in any way regulating the use of contraceptives, nor were there any laws regulating abortion before quickening, that is, before roughly the halfway point of pregnancy. The use of contraception and abortion became increasingly common in the 19th century, and this was so because unlike the largely agrarian rural world of the 18th century, in which children were seen as an important economic asset, the greater urbanization and industrialization of the early 19th century created a situation in which large families were increasingly seen as a financial burden that could indeed lead to a family's ruin. So over the course of the 19th century, the birth rate declined from 9 at the beginning of the century, 9 children per family at the beginning of the century, to only 3 by the end of the century. And this was not simply an accident. By the 1850s, contraception and abortion were widely recognized in society as legitimate means to maintain and improve a family's welfare. And advertisements for both contraceptives and abortion were commonplace. An English clergyman who toured the United States at mid-century was struck by the prevalence of small families and noted, quote, that there is no secret as to the various means resorted to for achieving this result. They are advertised, he wrote, in every newspaper in every city across the nation. This led to an increasingly voiced concern among moralists of this era that the widespread availability of these means of birth control would enable women not only to control their family size, but also to erase the consequences of their premarital and extramarital sex. As one mid-century moralist put the point, quote, if women need no longer fear pregnancy as the outcome of their immorality, what will keep wives faithful and daughters chaste? It was at this point that Anthony Comstock entered the picture. The son of pious Connecticut farmers, Comstock enlisted in the Union Army in 1864. And although he expected to find camaraderie in the military, he instead wound up complaining bitterly about his fellow soldiers' rampant sin and wickedness. After the war, Comstock moved to New York City, where he launched a personal campaign against immorality. When he was a 24-year-old sales clerk in a dry goods shop, one of his friends died from a mysterious ailment, most likely a venereal infection. Believing that the ready availability of erotica, which was everywhere in New York City, to have been the cause of his friend's demise, Comstock set out to destroy the city's extensive marketplace in pornography. He was very efficient and aggressive about this, and the leaders of New York's Young Men's Christian Association, YMCA, were so impressed with Comstock's vigor, energy, and commitment that they soon offered him a full-time job so he could pursue this cause more effectively. After he organized an ardent group of supporters and agents, which he named the Committee for the Suppression of Vice, Comstock initiated raids on several local publishers. But he soon discovered that if he really wanted to make a major impact on the pornography market, he needed federal legislation. And so with the enthusiastic backing of the YMCA, Comstock journeyed to Washington to lobby for a new federal bill to kill what he described as the, quote, hydra-headed monster of pornography. On March 3, 1873, Congress enacted an act for the suppression of trade-in and circulation of obscene literatures and articles for immoral use. The new law established a broad ban on all items that could be deemed, quote, obscene, lewd, lascivious, or filthy. 6 categories of objects were explicitly prohibited in the new act: pornography, contraceptives, abortifacients, information about contraception or abortion, sexual implements and toys, and advertisements for any of the above. The law authorized severe penalties, including hard labor, and it empowered the post office to censor and confiscate any objectionable material. Fittingly, the law came to be known historically as the Comstock Act. That act, which fundamentally changed American law, reflected the belief, vigorously advanced by Comstock and others at the time, that information about contraception was obscene because it dealt with sex and because it could have the effect of facilitating what they thought to be immoral sexual conduct. As Comstock put the point, quote, religion and morality are the only safe foundations for the nation's posterity, and laws enforcing those beliefs are necessary to prevent the ship of state from being dashed to pieces upon the boulders and quicksands of immorality. In the 20 years after Congress enacted the Comstock Act, most states, acting out of the values of the Victorian era, enacted similar laws, which became known as Little Comstock Acts. Many of these statutes went even further than the federal law. Some made it a crime not only to sell or distribute information about contraception, but also to possess such information, to discuss contraceptives orally with others, or to use contraceptives privately. Comstock and his followers aggressively enforced these laws. To cite just one of many thousands of possible examples, Comstock targeted and relentlessly pursued Ida Craddock, a middle-aged marriage advice writer who had published a rather conservative sex manual for married couples in which she discussed the use of contraception. She was repeatedly prosecuted and harassed by Comstock and eventually exhausted by her sequential prison sentences. She, like more than a dozen of Comstock's targets, eventually killed herself in despair. The Comstock laws did not go unopposed. In 1878, for example, the National Liberal League, which objected to the injection of religion into government policy, sent Congress a petition with 70,000 signatures protesting the Comstock Act's ban on information about contraception. And many physicians in this era also rejected the view that contraceptives should be outlawed. They insisted that family limitation was a sound and reasonable choice, and that the morality of such choices was not a proper subject for legal intervention. But these protests were to no avail. The late 19th century social purity movement, which aggressively sought to outlaw pornography, alcohol, gambling, prostitution, abortion, and contraceptives, was a powerful political force that dominated this facet of American politics until well into the 20th century. Interestingly, women's groups were themselves ambivalent about contraception and abortion. Many feminists were concerned that a focus on reproductive freedom would draw attention away from their larger demands about reforming laws relating to marriage and divorce and seeking to obtain the right to vote. And they therefore stayed away from disputes over what was seen as sexual-related matters. The federal and state Comstock laws made it especially difficult for poor women to obtain information about contraception. Although wealthy and middle-class women generally could obtain access to both contraception and abortion through their doctors, many of whom were willing secretly to violate the law, which they saw as unjust, the vast majority of women, and poor women in particular, were left largely in the dark, often with grievous consequences. And it was here that Margaret Sanger enters the picture. Sanger's father, a free-thinking socialist and soapbox orator, encouraged young Margaret, who was born in upstate New York in 1879, to think for herself and to have the courage to defy conventional wisdom. And in this, he proved enormously successful. Sanger moved to New York City in 1911 and soon became part of the radical culture of Greenwich Village. Trained as a nurse, she tended obstetrical patients in the tenement districts on the Lower East Side of New York, an experience that exposed her for the first time to the squalor and suffering that were caused by the devastating combination of poverty and unwanted pregnancy. Sanger wrote at the time about how pregnant women, desperate to avoid childbirth, brought themselves around, that was the phrase, by drinking turpentine, by steaming over boiling hot chambers of turpentine water, by rolling themselves downstairs, and by inserting elm sticks, knitting needles, and shoe hooks into their uterus. After treating several patients for septicemia, a deadly disease associated with the use of unsterilized abortion tools, and then watching them die, Sanger decided to take action. She later wrote that as a result of her experience at that time in her life, quote, "I resolved then and there that women should have knowledge of contraception. They have every right to know about their own bodies. I would strike out. I would scream from the housetops. I would tell the world what was going on in the lives of these poor women. I would be heard." Because of the blanket suppression of information about birth control, however, Sanger found it impossible to learn anything herself about what methods of contraception worked well, what were safe and what were not safe, and in what circumstances they made sense. She therefore journeyed to France in the summer of 1913, where such information was available. And she returned to New York more certain than ever that family limitation had to play a central role in, quote, lifting up the plight of working women. The following spring, Sanger rallied a small group of radical friends in her New York City apartment to launch a new feminist monthly, The Women Rebel, that would address issues of interest in particular to women, including marriage inequity, the treatment of women in the workforce, and most especially a woman's need to control her own fertility. In defiance of the Comstock Act, Sanger announced in the very first issue of The Woman Rebel that she would, quote, advocate the prevention of contraception, and that she would impart such knowledge in the columns of this paper. It was at this time that Sanger and her group first coined the term birth control and initiated a campaign that grew into one of the most far-reaching social reform movements in American history. The Woman Rebel's first issue focused on class differences with respect to birth control, and Sanger contrasted the women of the upper class who, quote, have available knowledge and implements to prevent contraception with the women of the lower class who, she said, are left in ignorance and despair. She wrote that it was a woman's duty to look the world in the face with a go-to-hell look in her eyes and to speak and to act in defiance of convention. A few days later, the postmaster of New York informed Sanger that the first issue of The Woman Rebel was unmailable and would be confiscated under the authority of the Comstock Act. And shortly thereafter, federal officials arrested Sanger for violating the act. In protest, a group of prominent progressives founded the National Birth Control League, and 2 months later, an overflow crowd of more than 2,000 of Sanger's supporters attended a meeting on birth control at the New York Academy of Medicine, at which several doctors publicly called for a change in the nation's policies. Comstock raged in response to this event. Quote, "Can't poor people learn self-control? Can't everybody, whether rich or poor, learn to control themselves? Are we to have homes or brothels?" A prominent supporter of Comstock insisted that wives who wanted to have sex without the risk of pregnancy were no better than prostitutes. And a leading opponent of women's suffrage declaimed that the fear of pregnancy was the last barrier against women's innate immorality. Despite these views, attitudes, however, were beginning to change. The 40-year public silence on birth control had been broken by Sanger, and birth control leagues soon were established in cities across the nation. Several months later, the charges against Sanger were finally dismissed because the prosecuting attorney did not want to make her into any more of a martyr than she already was. After the dismissal of these charges, Sanger made up her mind to open the nation's first birth control clinic in a working-class neighborhood of Brooklyn. This was blatantly unlawful. Sanger wanted to recruit a doctor to run the clinic, but even sympathetic doctors were unwilling to challenge the law in so direct and open a manner. And she therefore signed up her sister, Ethel Byrne, a registered nurse, for the task. On October 16, 1916, Sanger, Byrne, and their staff opened the nation's first birth control clinic. For a 10-cent registration fee, women could get instruction on how to use a range of contraceptive devices and information about how to obtain those devices. This was all in clear violation of New York law, which made it a crime for anyone to sell, distribute, or exhibit contraceptives or to impart any information about how to use them. Sanger and her staff distributed leaflets announcing the opening of the clinic, and more than 100 women came on the first day. Most were working mothers, chambermaids, scrub women, and sweatshop workers. One woman had had 15 children by the age of 36. Another had 7 surviving children out of 11 and had self-aborted more than a dozen times. One woman, a Russian immigrant, told Sanger, "God must have sent you to us. We are too poor to pay a doctor to tell us what you have told us. If the police fight you, they must fight us too." A few days later, predictably, Sanger and Byrne were arrested and their clinic was shut down by the authorities. Byrne was tried first. She was convicted and sentenced to 30 days in Blackwell's Island prison. She immediately announced that she would provide birth control counseling to the women in the prison. She also went on a severe hunger strike. And this action, combined with her deteriorating health during the course of her incarceration, drew national attention as prison officials had to force feed her just to keep her alive. When Sanger's trial began, the courtroom was packed with supporters. They were both, quote, shawled and tired-faced slum mothers and smartly dressed socialites, all of whom were dedicated to Margaret Sanger and to the cause of birth control. Like her sister, Sanger was convicted and sentenced to 30 days in prison. The judge offered her clemency if she would promise henceforth to obey the law governing contraception. Sanger refused, stating defiantly, "I cannot respect the law as it stands this day." In the 19th century, religious institutions did not play a dominant role in the effort to prevent women from exercising reproductive control. That changed dramatically in the early 20th century as the Catholic Church took on a more aggressive role. In 1916, the well-known Catholic priest, Father John Ryan, published a widely circulated article in which he condemned contraception as a mortal sin. Shortly thereafter, the American archbishops of the Catholic Church published a pastoral letter that condemned as immoral the notion that economic and domestic considerations could justify efforts to prevent conception, and insisted that such selfishness is, in God's sight, detestable. In increasing numbers, priests began to speak out publicly against birth control, and Catholic organizations increasingly condemned those who sought to promote contraception. In March of 1917, Pope Benedict XV responded directly to the agitation over birth control in the United States, and several Catholic publications printed strident attacks on Margaret Sanger personally. In the meantime, after her release from prison, Sanger made some 50 speeches on birth control in cities across the country. In a new book, Woman and the New Race, she wrote that, quote, "The most far-reaching social development of modern times is the revolt of women against sex servitude. No woman," she wrote, "can call herself free until she can choose whether she will or will not be a mother." In 1921, Sanger organized the first American birth control conference at the Plaza Hotel in New York. The 3-day event brought together a broad array of internationally respected speakers, including economists, eugenicists, gynecologists, biologists, and social scientists. On the final night of the conference, the New York police raided the hall, dragged Sanger off the stage physically, and carted her off to a police station, followed by hundreds of angry protesters. The following day, the press reported that Catholic Archbishop Patrick Hayes had pressured the police to shut down the meeting. 2 days later, Hayes issued a statement in which he challenged the morality of the birth control movement, declaring that, quote, "The law of God, public policy, and human experience all condemn birth control as preached by a few reckless and irresponsible individuals." Sanger responded directly by questioning the morality of Catholic doctrine. A furious Archbishop Hayes answered Sanger in a vehement pastoral letter in which he declared, quote, "Children troop down from heaven because God wills it. Woe to those who degrade, pervert, or do violence to the law of nature as fixed by the eternal decree of God." He damned birth control as satanic and as an unclean abomination. Sanger not daunted, shot back that she had no objection to the Catholic Church inculcating its doctrines to its own people, but declared that its effort to, quote, enforce its opinions and code of morals upon those who do not share its teachings is an unwarranted interference with the most fundamental principles of this democracy. Despite the fervent opposition of the Catholic Church, the birth control movement gained strength in the Roaring Twenties, as Americans became more comfortable with the idea of sex in all of its many dimensions. This was, after all, the generation of flappers, dance halls, and the back seats of Fords. The new woman of the post-World War I era was daring and flirtatious in a way that would have been impossible in the Victorian era, when the values of Anthony Comstock reigned supreme. The Catholic Church, however, continued and deepened its opposition. In Albany, the mayor succumbed to Catholic pressure and prohibited Margaret Sanger from speaking. In Boston, the Catholic mayor, James Curley, banned Sanger from speaking at all in the city for several years. More important, the Catholic Church was extremely effective at blocking proposed legislation that would have repealed the contraceptive provisions of the state and federal Comstock laws. Even legislators who themselves used contraception were unwilling to take on the church politically. On December 31st, 1930, Pope Pius XI condemned birth control as evil and ushered in an even more determined era of Catholic clerical attacks on contraception and on its supporters. In such circumstances, the issue of contraception was simply too politically hazardous for most legislators to take on, despite the continuing efforts of Sanger and other feminist leaders to change the laws. Connecticut Congressman William Citron, a Jew, for example, refused to support proposed legislation to amend the Comstock Act, explaining that, quote, the Catholics would crucify me if I voted for this bill. Despite all this, the contraceptive business was now booming in America. Although state and federal laws prohibited the sale of contraceptives, it was unclear what that meant when the device or substance was sold for other purposes, such as to prevent the spread of disease or to ease medical conditions, even though everyone knew why they were really being sold. A 1932 survey in western Florida, an area of the country known for its conservatism, found that condoms were for sale as devices to prevent venereal disease, or purportedly as devices to prevent venereal disease, in 376 retail outlets, including pool rooms, cigar stores, soda fountains, shoeshine parlors, and grocery stores. In some parts of the country, saleswomen went door to door peddling IUDs, diaphragms, and contraceptive jellies, all for purportedly non-contraceptive purposes. The legality of all this was very much unclear. Although Congress and state legislatures refused to change the law, judges in this era began to reflect the change in public opinion. In 1930, in a case involving a trademark dispute between two condom manufacturers, a federal court of appeals ruled for the first time that condom manufacturing was a lawful enterprise, and that condom manufacturers therefore were entitled to trademark protection. The following year, a federal district court exempted the importation of printed information about contraception from prohibition under the Federal Tariff Act on the ground that such material was not obscene. In 1933, a federal court of appeals ruled that the interstate transportation of contraceptive devices was not illegal unless the government could prove that the distributor intended people to use the product for illegal, that is, contraceptive purposes. In a groundbreaking decision in 1936, the U.S. Court of Appeals for the Second Circuit narrowly construed a federal statute that had been modeled on the Comstock Act. The case began when Margaret Sanger ordered a packet of Koyama suction pessaries from a doctor in Japan in order to test their effectiveness. The Federal Tariff Act made it a crime for any person to import into the United States any article whatever for the purpose of contraception. Customs officials confiscated the pessaries because they were commonly used for that very purpose. In the United States v. one package of Japanese pessaries, the Court of Appeals, in an opinion by Judge Augustus Hand, held that the statute did not prohibit the importation of contraceptives for lawful purposes. As an example, Judge Hand explained that a doctor could lawfully provide a patient with condoms to prevent infection or with a diaphragm to prevent a pregnancy that might endanger a patient's health. The court justified its narrow interpretation of the statute in the following manner, quote, "This statute covers only such articles as Congress would have denounced as immoral if it had understood all the conditions under which they were to be used. It was not intended, Judge Hand said, to prevent the importation of things which might intelligently be employed by conscientious and competent physicians for the purpose of saving life or promoting the well-being of their patients. There clearly had been a dramatic shift in public opinion since 1873. As Judge Learned Hand observed in his concurring opinion in one package, many people have changed their minds about such matters in 60 years. By the 1930s, nationwide polls indicate that as many as 70% of Americans supported the dissemination of birth control information. And in 1937, the American Medical Association, for the first time, expressly endorsed the dissemination and teaching of birth control methods, all of which were still illegal. By 1843, 85% of women and 2/3 of Catholic women favored the availability of contraceptive advice for women. Nonetheless, the Comstock Act's prohibition on the mailing of contraceptives and on the mailing of information about contraceptives remained in place. Finally, in 1965, the Supreme Court of the United States held that Griswold versus Connecticut that a state could not constitutionally prohibit the sale or distribution of contraceptives to married couples, merely because the state thought that such products were immoral. And several years later, the Supreme Court in Eisenstadt versus Baird extended that holding to unmarried couples and unmarried individuals as well. Congress finally repealed the contraceptive provisions of the Comstock Act in 1971. The decisions in Griswold and Eisenstadt, which recognized the fundamental constitutional right of the individual to decide whether to bear or beget a child herself, ultimately laid the foundation for the Supreme Court's 1973 decision in Roe versus Wade, decided 40 years ago last month, which finally brought the nation back to where it had started at the time the Constitution was adopted. Okay, questions? No questions?
What about the other sexually explicit materials in the Comstock Act? Were they prohibited before contraceptives, or what was the Catholic Church's opposition to those in comparison to the contraceptives?
There was no ban on what we today would call obscenity in the United States until 1815. So all forms of pornography were legal and were widely distributed until the early 19th century. And it was really the result of the Second Great Awakening, the sort of evangelical fervor that swept the nation from 1800 to the 1840s, that laws against obscenity were first adopted. I don't think the Catholic Church had anything really to do with that during that era. The Comstock Act was the first federal law to prohibit the interstate mailing of obscenity. The definition of obscenity in that era, once the doctrine took hold, was very broad. It covered basically anything dealing with sex. And that remained the case until the 1920s and 30s, when courts began re-examining the question of how broad the definition of obscenity could be. And that process has more or less continued with some ups and downs over the years since then. But it was really in the 20s and 30s that it began to change, and then the court, roughly at the same time as these decisions, 1957 in the Roth case, in which the court for the first time addressed the constitutionality of laws against obscenity, and then in a series of decisions between 1957 and 1973, the same year as Roe, attempted to figure out how to define obscenity, which has proved to be a pretty intractable problem. And then in the years since 1973, although the definition has remained the same under federal law, the practical reality is that what constitutes obscenity has shrunk down to almost nothing. So that material in 1973 that would clearly have been recognized as obscene is today readily available on HBO. And you wouldn't think twice about it, and yet all that would have been banned only 35, 40 years ago.
You said that at the time of the enactment of the Constitution that there wasn't really obscenity laws or birth control laws. How much of that is that we just didn't think it was a good idea to regulate that, which it has the technology to, have obscene material. I mean, when you're doing charcoal paintings on a cave wall, you can only get so explicit. So, how much of it was we had new technology in birth control, we had new technology in our ability to make obscene material, and immediately after that we got laws versus it was a change in preferences.
So the material that was available in Philadelphia or New York in the 18th century couldn't be movies, of course, couldn't be videos, but both in written form and in painted form or artistic form was as explicit and filthy and lewd as anything you could imagine. Right? So it was not as if the material was tame, and it was not as if it wasn't widely available. It just wasn't, it was thought to be not a matter of legal intervention. Obviously, the ability to have sexually explicit material once you get into videos and movies and so on is different from what could have existed then. But what existed then was extremely raunchy and was totally illegal in the United States after the mid-19th century. The same material was deemed illegal. So I don't think technology had anything to do with the shift in the law in that era. With respect to birth control and abortion, well, abortion was certainly possible and done in that era in the kind of ways that Sanger was talking about in the early 20th century. Those methods all existed forever and were employed. Contraception, there were cruder forms of contraception, right? Apart from simply coitus interruptus, I mean, there were early condoms. There were condoms as early as the 1600s, but they were they tend to be made out of sheep intestine, and there were a variety of home remedies that people took to essentially abort in their first moments of conception, sort of like the morning after pill. Whether they were effective or not remained, was highly speculative. But there was a lot of talk. There were diaphragms that existed, pessaries that existed. So there were blocking devices. So that all of that existed at the time. I mean, that did become more technologically sophisticated as you get into the 19th century with the development of rubber and the ability to make rubber condoms. That was a significant change in terms of the availability of that kind of contraceptive. But the others existed in the 18th century as well. No one wants to talk about sex?
I think you mentioned that at one point there were laws on the books that outlawed actual speech about contraception, like you can't start a clinic to teach someone about contraception. Were there any First Amendment challenges to those types of laws?
Well, first of all, insofar as they were state laws, the First Amendment wasn't relevant yet because it hadn't been held applicable to the states until 1927. So there would have been no federal constitutional issues. But beyond that, no court really regarded speech about sex, including contraception, as protected by either state or federal constitutional guarantees. It was simply seen as obscenity. And so the Comstock Act basically treated information about contraceptive as if it was obscenity. Right? So you just couldn't talk about sex. And contraceptions were about sex, and that was the end of that. Right? So yeah, so that they were prohibited in a part under the umbrella of obscene speech. Yeah.
Oh, okay. I was going to ask, how do you some people reconcile this almost crude hypocrisy that at the same time that they were fighting, this quote resonated with me about the women have the right to know about a contraception, but it's the same sort of political movement that gave rise to freedom of speech in this realm that sort of has worked against cases like IMS versus Sorrell or off-label drug promotion. That seems to be the exact same type of free speech, and the people who are promoting that are the people who are pushing for anti-pornography laws and probably contraceptive laws and stuff like that. So, I mean, just like, what's the cognitive dissonance that allows people to sort of do that?
Okay, so if I understand the question, it's why is it that some people will support some forms of free speech and not others? That's a fair question. I mean,
No, but I mean, promoting condoms, it's a commercial product.
Right.
But then you don't allow people to promote truthful information about drugs or truthful information like Anonymous versus oral. Yeah, so I guess.
well, look, insofar as the question is the nature of the product, right? The issue was not so much about commercial advertising as a category. It was about this product should not be advertised in particular, because this product is immoral and indeed is illegal. So I don't think it was difficult at that time for people to distinguish between commercial advertising of many products and commercial advertising of contraceptives.
So it's just because they were trying to push that, not that you can't disseminate information, but it's an illegal product, so you can't talk about it.
Well, see, the product wasn't illegal in most states, right? So you have there are different levels because of federalism. There's different levels of what we mean by illegal. So the federal law didn't make it a crime to own contraceptives in your house, right? It couldn't reach that, right? It was about the mails. It was about interstate shipment of contraceptives. So contraceptives themselves were not illegal under federal law, right? That depended on the states. Some states, like Connecticut, made contraceptives illegal. Other states prohibited the dissemination of information about contraceptives, but not the contraceptives themselves. It would be a little bit like a state that wanted to allow cigarette smoking but to ban advertising for cigarettes, right? So you want to discourage it, but you're not prepared to outlaw the actual use of the material. Other states prohibited the use of the material, contraceptives itself, like Connecticut. I'm not sure I'm responding.
Yeah, it's probably a rubbish question. It was just rubbish straight to me. Just sort of the. I mean, I just see it as like the same type of speech that's being regulated on one side and not being regulated in other instances.
But again, is the question why do some people? I'm going to come back to the way I phrased your question.
I guess it can be boiled down to that, but I'm just sort of curious as to the distinction versus, like promoting off-label drugs versus, promoting condom usage or something like that.
Okay, so I think I've answered as best I can.
About the Catholic Church beginning to take a stance against contraception, are you saying that like the Catholic Church's stance against contraception was always there, and then they just decided to voice that opinion starting at that time, or are you saying that at that time the Catholic Church started incorporating that stance into their doctrine, or like was it an arbitrary decision?
The Catholic Church's position on contraception goes well back before the 20th century. But until then, the Catholic Church, for the most part, stayed out of American politics.
Can you speculate on why they began to take us more?
Well, partly because the population of the country became much more Catholic with the wave of immigration in the late 19th century. So with Irish and Italian immigrants coming into the country and so on, Catholics went from being a very small minority, which always felt a little precarious itself, right, to being much more of a political force. And that enabled them and empowered them to take a more active role in attempting to shape laws. But until the late 19th century, Catholics would not have and did not play that kind of a role. Because they themselves saw themselves as A, they were too few, and B, they were themselves nervous about their acceptance in the society. Yeah.
We talked a little bit about the chilling effect those laws created in regards to the development of contraception, but did it have other effects, like in the study of venereal disease or obstetrics in the United States, that we can really quantify, or was it mostly focused on the contraceptive arena? Because it seems like those things bleed into each other a lot.
A large issue in the mid-19th century had to do with this is more on the abortion issue than the contraception issue, had to do with the early medical profession's effort to gain control over healthcare in the United States. And so until the last third of the 19th century, women tended to go to midwives for obstetrical advice and help. And the medical profession wanted to get control of that. It's big business, right? So in around the same time as the Comstock Act, a little earlier actually, a decade or two before, the nascent AMA, it had just been formed, right? It went after abortion big time. And it was really the AMA that led to the prohibition on abortion in the United States. Until the AMA decided to go after abortion, the basic English common law rule that abortion was not illegal before quickening was the universal position. But the AMA went after that, in part in good faith, I think, because of a belief that abortion was morally wrong, but clearly also in part because of an effort to drive midwives out of existence. And effectively, they did that. So in that sense, these issues were bound up in the professionalization of healthcare in the United States and with the effort of doctors to control that healthcare. And so it was interesting that the movement against abortion in the United States was not led by the Catholic Church, it was not led by the evangelicals, it was led by the AMA, and an AMA in its early years. But if you read the arguments they make, they're all moral arguments, right? They don't make the argument that, give us the business of taking care of women, right? But the arguments were all made as religious, moral arguments, but fundamentally what was driving it was economic power. And it was completely effective, because in the end, the only people who could authorize abortions were doctors, as a result of the laws that were enacted in that era.
Was the abolishment of the law in 71 an isolated act, or did at the same time other laws putting forward some rights of women like divorce occur at the same time?
Is that in 1971?
Yes.
No, 1970. That was. I think that was a simply one-off amendment of the federal law on obscenity, and it basically eliminated the Comstock Act and put in place a new law that was more consistent with contemporary legal concepts and values. I don't think it was part of a larger. I mean, again, it was part of the women's movement. So in that sense, it was very much the product of the cultural change with respect to women's rights in that era and sexual rights in that era, to go back and look at the act. And by 1971, the act was obviously obsolete. It wasn't being enforced against anybody anymore. And indeed, it had effectively been held unconstitutional in Griswold and Eisenstadt, so there was no real point in the statute anymore. So I think it was part of the same movement that led to the Congress's approval of the Equal Rights Amendment and laws protecting women against discrimination, but it wasn't part of a massive overarching piece of legislation, but it was certainly part of the times, right?
So the way that you're describing it, it seems like the anti-abortion movement was premised on deterring women from having sex outside of marriage, in a sense. And whereas now, sort of the anti-abortion movement is largely premised on protecting the rights of an unborn child. So can you speak to sort of like when that shift in, I don't know if it's legal doctrine or rhetoric or just popular thought in general sort of shifted?
In the abortion context, this occurs with the AMA's involvement.
Okay.
So before then, the quickening rule, okay, so go back to the English common law. The rule was it was not illegal to abort before quickening, because the theory was there was not another person there until you could feel the child. And before then, you were just bringing on your period, basically. Right? That's how it was thought of. And after that point, the law recognized there was another child, and it was a misdemeanor to have an abortion. What the AMA did is basically base its position on its conclusion that the other life exists at the time of conception. And there were some really nutty arguments AMA made about how, from the moment of conception, the fetus can think. It's a person in a full sense. I mean, they were actually arguing it was a person like a person, as opposed to some more complicated notion of a soul or whatever. But that's when that change takes place. And part of it comes out of the Second Great Awakening, out of the evangelical movement about the first half of the 19th century, and some of it comes out of the AMA's movement. But it was really the AMA that took the point and really ran with it. And the claim they made was a medical one, right? The claim they made was that the person exists at the moment of conception. And therefore, quickening is the wrong line, and we have to move it back. So that's when that change took place. That was roughly the 1850s. Yeah?
Kind of the flip side of her question, when did the sexual freedom rhetoric enter the birth control movement? It sounds like Sanger wasn't really making that, it was more just controlling family size. When did that shift?
Sexual freedom really begins, I think, as an argument in the 1960s with Betty Friedan and so on. There's some of this in the 1920s. There's early elements of it in the 1920s. And you see things like Mae West, who did, the actress, who producer, who did plays on Broadway that were really designed to push the limits about legitimating the roles of women sexually. But the real force of what you're talking about comes into being in the 1960s, where we begin to think about sexual freedom in addition to. So what used to be deemed, it was illegitimate to have sex except within marriage, period, right? By the 1960s, that notion gets exploded. And the argument is that sex is something that goes beyond reproduction, it goes beyond marriage, and it's independently something we have a right to, whether a constitutional right or not, we have a right to, and therefore the conditions that are necessary to enable people to exercise that right, like birth control, are for that reason also independently a right. So but that's really the 1960s. Even in the earlier time, in the 20s, when the idea of sexual freedom began to be discussed in that era, it was not about contraception. It wasn't connected to contraception then. It was more just about redefining the roles of people and women in particular. Nothing else? Want to talk about Roe? Any questions about Roe? I was the law clerk that year. Any questions about Roe? Well, you're an uncurious group. Margaret Sanger would be really horrified.
This isn't about Roe, but could you talk a little bit about the contemporary issues about birth control? I'm thinking specifically about these like the Hobby Lobby cases and the cases where saying provision of birth control to employees through the ACA is a constitutional religious violation of the owner of the company, and kind of how that plays into this.
So this raises the free exercise of religion notion, that to what extent can the state require individuals to engage in conduct that they have a bona fide religious objection to doing. And it arises both in the same-sex marriage context today, big time, and in the contraceptive context under the recent legislation. And so one way of looking, so first thing you have to do is divide the world into two categories. Both the Supreme Court and all legislatures have basically recognized, either as a First Amendment matter or as a statutory matter, that religious institutions themselves, by which I mean churches, synagogues, whatever, cannot be compelled to do things that are incompatible with their religious beliefs. So on that score, there's really no doubt. No state would be likely to require a Catholic priest to perform a same-sex wedding. And if they did, no doubt the court would hold it unconstitutional. And so when you're talking about the pure religious institutions themselves, that's where that right of free exercise is at its highest. And as long as there's a sincere religious objection to doing the thing, both courts and legislators are going to respect that. Okay, where it gets trickier is when you move down the scale, right, of distance from the core religious institution, and a much and a reduced confidence that the claim of religious conviction is quite so sincere or so deeply felt. So the pharmacist, for example, who doesn't want to prescribe contraceptive because he's Catholic, is one model of this problem, right? Or the hotel that refuses to allow a same-sex wedding to take place in it because they believe same-sex marriage is completely incompatible with their religious belief. Or the Notre Dame that doesn't want to have to provide contraception in its healthcare provisions for its employees. So in those cases, the law in an earlier era, in the Warren Court era, basically said that when the state intrudes upon the religious freedom of the individual in this way, that the state has to have a sufficient justification for doing so. So that is, the individual can raise, under the Free Exercise Clause of the First Amendment, a legitimate argument that the state can't compel me to do this thing which violates my religious beliefs. And the court was prepared to allow exemptions, constitutionally compelled exemptions from such laws under the Free Exercise Clause. Then Justice Antonin Scalia, in the Smith versus Employment Division case, which involved a claim of Native Americans to use peyote in their religious rituals, which was clearly sincere and traditional, in defiance of federal law prohibiting use of peyote, Justice Scalia rejected those earlier decisions and essentially said that there is no free exercise right other than the church itself to have a constitutionally compelled exemption from a law that's not directed at religion itself. And so, as a constitutional matter, that being the current state of the law, one would expect courts to say, in these circumstances, that, given the decision in Smith, that the hotel owner cannot opt out of an anti-discrimination law prohibiting discrimination against same-sex marriages, or Notre Dame cannot opt out of the requirement that it provide contraceptive coverage for its employees. Even if their religious beliefs are sincere, they're just like the Native Americans who want to use peyote. And that decision should, I think, just taking a legal standpoint, make all those cases easy as a constitutional matter. Now, I happen to think Smith is wrong, and my own view is that the prior jurisprudence was a better understanding of the Free Exercise Clause, and that the state does have a constitutional obligation to respect the religious beliefs of individuals, and that if there is a real legitimate conflict between what the state wants to compel someone to do and that person's sincere religious beliefs, that the state should not be able to compel that without an adequate justification, adequate being obviously vague. And it'll be interesting to see how courts deal with this problem. But under the existing law, it seems to me completely clear that there's no claim that can be asserted in these cases. If I were applying the pre-existing law, the law that existed in the 1960s and 70s, I would be inclined to respect the interests of these objectors insofar as there are alternative ways, reasonably alternative ways for people to get what it is they want. So if there's another pharmacy across the street or another pharmacist in the same pharmacy, I'm not sure the state has enough of a justification to compel a pharmacist to quit his job because he can't morally do, given his religious beliefs, what the state would ask him to do. And the reason Scalia took the position he did is this is messy, right? Trying to figure out, with the church itself, it's pretty easy. You know what the church's beliefs are. They're unequivocal. That's pretty straightforward. When you start getting into these other situations, the application of the test is very difficult. But so that's what the courts are going to have to grapple with. If they follow Smith, these were easy cases. I think these cases will cause some judges to reconsider Smith, like say Scalia. And I don't know where they'll come out on that then. Time for one more question.
Were
So
there any regional
we got.
Were there any regional variations, or I guess different state opinions in the whole anti-abortion movement? I guess how did that sort of play out?
So the question is whether regional variations in the anti-abortion movement, right? In the 19th century. Good question. My sense is that these laws kind of swept the country over a 20-year period, and there was no state that I'm aware of that did not adopt a law prohibiting abortion in this 20-year period, in the mid-19th century. So there may have been variations, but again, because it was AMA-driven, it was kind of like this wave of suddenly saying, doctors are telling us we have to do this, so we should do this. And abortion was never, it was never something people were comfortable with. I mean, it was fairly open, and it was advertised, and it was fairly widespread, but there was always opposition to it, and it was always conflictual. So this gave an impetus to tip the balance in favor of just prohibiting it. And there was not much objection to it, because even women's groups in that era were very uneasy about taking this position. They had, as I indicated, they had bigger fish to fry. And Sanger, by the way, was furious at the women's groups at the time on the issue of contraception. Sanger herself, by the way, opposed abortion. But on the issue of contraception, she was furious at the women's groups for not taking on the contraception issue. I mean, her view is that this was completely missing the forest for the trees to say you're interested in women's rights, but you don't care about access of women to contraception. That women can't have meaningful rights in a society in which they are going to have 13 children. And so she was very much at odds with them for several years until they came around to the other point of view. Okay, thank you all very much.